defendant struck Mark Koster and hit him in the head. When Mark Koster was on the ground, the defendant made the decision to get on top of him. The defendant made the decision to place an object, a weapon, on his throat. The defendant made the decision and held that weapon against Mark Koster's throat. Held it with such force that Mark Koster was left grunting. The defendant was grunting because he was using such force. He was using the force to kill someone. And that's what he did. He held it there. By his own words, it seemed like an eternity. He held it there until he strangled the life out of Mark Koster. Actions speak louder than words. The defendant didn't just get on the phone and call the police and say, "Oh, my friend Mark attacked me, please get over here, I need help." No. He had just committed a murder. So what he had to do was get rid of the body. And that's what he did. He took Mark from the living room area, drug him through the kitchen, down to the steps on State's Exhibit 4 of the diagram. State's Exhibit number 6. He didn't just leave him at the bottom of the steps, folks. And he didn't just leave him at the floor, being in shock. He could have just left and say, "I was just in shock, I didn't know what to do." He didn't do any of those things. His actions were, I committed a murder, I have to get rid of the body. And if he's going to get rid of the body, he's not going to lay it at the bottom of the steps. He's going to take it, go around the corner to the deepest, darkest area of the basement. And that's what he did. But folks, he didn't just put Mark Koster's body there and then take off. Oh no. He is going to conceal this. He is going to conceal this to the extent that he wants no one to find Mark Koster's body. State's Exhibit 23 is the back door area of Mark Koster's home. You've seen that photographs, and you'll get the photographs and go back to the jury room. State's Exhibit 28 is down the steps where he drug Mr. Koster. He took Mark down there. State's Exhibit 47. State's Exhibit 47 is one of the blankets. And the reason the defendant used blankets is apparent. The defendant says he was in shock today and just didn't know why he used blankets. Is he's covering up the body. He doesn't want any type of smell or odor to come from the basement so people know that he's down there. And he doesn't just use one blanket. State's Exhibit 48, he uses a heated blanket. He wraps that around him. And then he doesn't just stop there, folks. State's Exhibit 39. This is in the back of the basement after they found Mark. What the defendant has done is, this is a grave. He went out and got cat litter, not because he was in shock and just driving around and ended up at the dollar store and thought, well, I'll get 4 or 5 bags of cat litter, see what I'll do with it. He knew exactly what he was doing. He was going to spread that cat litter on there, and then he's covering up Mark's body. If things go as planned, no one would find Mark Koster. He just left. And Mark was kind of a loner, so no one misses Mark. The defendant gets away with the murder. But then he puts other items on. He goes to the extent of stacking the items. State's Exhibit number 37. You've seen those photographs. State's Exhibit 36. State's Exhibit 33. The table he actually used as a border to kind of put around so you can keep everything in there, an area. But he doesn't just stop there, folks. This one, he went to the extent of a 250-pound to 300-pound water heater, which you see in the upper hand corner of State's Exhibit 34. Bleach bottles, detergent bottles. State's Exhibit 32. He lays that on top. Why? Why do you put a 300-pound weight on something? Because the average person coming down there is thinking he's going to look and say, don't see anything there. I'm not going to do the effort of lifting that up. Because that's what he did. He wanted to cover up a crime. You don't go through all that effort and trouble on a self-defense. State's Exhibit 31 is more of the items that were taken off. State's Exhibit 25 shows some of the items in the trash can that Mr. Galeston had taken off. But it doesn't just stop there, folks. Actions speak louder than words. There's blood. Why is there blood? Because the defendant hit Mark. He was bleeding. And why does he have to clean up blood? With self-defense, folks, you don't have to clean up blood. Hey, he came at me, he hit me, it's just defending myself. But when you murder somebody, the last thing you want to do is leave evidence behind. And that's what he did. He cleaned up his blood because he knew this was a murder. And did he put the rags just out at the curbside? Absolutely not. He got rid of those rags. He didn't want any connection. How about the murder weapon? Did he just leave that there? The defendant claims today that he came at me and I hit him and we're down and we're struggling. It's not what he told the police in March. It's not his story. But think about it. If it truly was self-defense and he got attacked and the bat came at him, you'd want to keep that. Because you'd want to show the police, this is what he used. This is what he came at me with. But if you kill somebody, you have a murder weapon. You don't want that murder weapon around. And that's what he did. He got rid of it. But now, he's not in shock at this point, folks. Use your common sense. This is 2 to 3 days he said he was there. He is still manipulating that scene. And does he stop there? Well, if Mark's gone, let's leave a note so everybody thinks he is gone. So let's put the note, gone to Florida with, maybe not John, that might be too obvious. Let's put Tom. He put Tom for a reason. He knew Tom Balky and Mark Foster were friends. At least we go that direction. Not the direction with John Green, who's leaving. He props open the refrigerator because he wants to make it look like the guy in his life. But he takes, before he leaves, he does take something. He takes his friend's wallet that has Mark's ID in it, and money, and leaves. He doesn't go to the police when he goes down to see his dad in Mississippi. He's no longer in shock 2 weeks later. How about 2 months later? Is he still in shock then? When he's in Mississippi with his dad and stepmom? Does he call the police and say, hey, I have to tell you, this is what happened? Absolutely not. Does he tell his dad? Does he confide in his dad? I want to tell you, Dad, I know I can trust you. This guy came at me and I didn't know what to do. He didn't tell his wife. He didn't tell his sons. He didn't tell anybody because it was a murder. It wasn't done in self-defense. And his plan almost worked. People saw the note, Sandy Dierenfeld. She thought, well, you know, he does leave. He usually tells me, but, you know, he's made gone. Dan Koster came over, and the utility company got hold of the sheriff's police department because Mark would pay his utilities on a monthly basis, and he was behind for a month, and that was odd. His mailbox got a lot of mail in it, but they saw the note. One thing Dan didn't see was State's Exhibit number 1. So one thing the defendant forgot to take or hide was Mark's pipe. Well, he didn't need to take it. He wasn't thinking because it wasn't used when he murdered Mark. So he didn't need it for that reason. But Dan says Mark's always has his pipe with him. So that was a red flag to Dan Koster. So for a year, 2 years, everybody thinks Mark's just out somewhere, traveling, no one knows. The defendant knows, not telling anyone. And for almost 5 years, he got away with it. Until March 25th, 2014, thanks to good investigative work by Chief Thompson and Assistant Chief Jansma, they go knocking on the trailer door in Florida. Defendant opens the window, they tell him who they are, and comes out. They tell him they're investigating an incident on Mark Costa. The defendants say, "Whew, thank gosh you guys got here. I've been waiting for almost 5 years to tell you that what happened is he came at me and I was protecting myself." No. Just goes along with him, goes down to the sheriff's office, and you've seen the interview. Beginning, where is Mark? Is Mark hurt? Why is he saying that, folks? It's not because I wasn't ready to tell him yet. He's saying that for a good reason. He doesn't know if they ever found him. As far as he's concerned, Mark's still a missing person. I don't need to say anything. Is he hurt? Have you ever been to Iowa? No, never been to Iowa. Why do you deny that? You're right there. They're talking to you, and if it really happened the way he claims it happened, you're like, "Oh yeah, I was there. I want to tell you what happened." Yeah. And then they confront him. They said, "It's really important. Have you ever been to Iowa?" And then he says, "When have I been to Iowa?" Well, yeah, when have I been to Iowa? He's trying to find out. Do they know? Do they have evidence that I've been to Iowa? Do I have to let them know when I've been there? And finally, when they confront him, he finally says, "Yeah, I've been to Iowa." Actions speak louder than words. What does he do next? Does he say, "Okay, I've been to Iowa. I got to tell you now. I'm ready to tell you"? No. He says, "Where's Mark?" And during the interview, they finally say, "Mark's dead." What happened? Tell me about the evidence. Tell me about the evidence? How about you tell us what happened? If it's self-defense, but it's apparent what he's doing is he knows what he did. He knew that 5 years ago. But he wants to know what law enforcement knows. He wants to know what they know before he tells his story. Because he wants his story to match the evidence. So these officers are good. They're not giving them what they have. They're not going to tell them. So they give him themes. Did he fall? Is it an accident? Did Mark come at you? They played on schizophrenia. First time they give him the theme of Mark came at him. I don't know. He's not admitting anything. What happened? Tell me about the evidence. He's not admitting it. They do the theme again. Then eventually, he comes up with a story. He finally grabs onto one of those themes, and he comes up with a story. And you saw the interview. The story at that time, his claim was Mark came at him with a baseball bat, hit him in the shoulder. Today it's a little higher, but it was his shoulder. And he sprung up. He grabbed the bat. He hit Mark. Mark went to the ground. That's what he told him. Then he got on top of him and then strangled, choked the life out. That's different than the story he said today. But that story he told the police, there may be issues with that story that may or may not be true, but it doesn't matter because with that story being said the way it was that day, that's murder in the first degree. That's not self-defense. And we'll go through those elements with you. You have these, you're going to get the instructions, so you don't have to worry about writing them down. There's 5 elements to murder in the first degree. The first one is on that on or about June 5th. And the reason we know it's on or about June 5th, you saw lots of records come in. Mark was paying his utilities, state exhibit 9 and 10 on a regular basis, the end of April, the end of May. We had a last deposit was April 2nd, 2009. We had a computer log on, and that was for the record, from State's Exhibit 8, 9, and 10. State's Exhibit number 12, we had the last shutdown time. That's where there's an actual power shutdown on Mark's computer. And that was at 12:02 on June 4th, which is a couple minutes after midnight. And then the next day, around 9 o'clock, State's Exhibit number 13, he had a logged on at 9:42. Then his last internet access was around 8 o'clock, 8:08 p.m. on June 4th. So we know around June 4th or June 5th, based on the circumstantial evidence, shows that's when Mark was murdered. Mark Hoster died as a result of strangulation, and the first one is not being contested. The defendant is just claiming that it was self-defense. The second element is not being contested either because you heard Dr. Thompson come in and testify that was the cause of death. So the first two elements, the state has proved beyond a reasonable doubt. The third element is the defendant acted with malice aforethought. The fourth, the defendant acted willfully, deliberately, premeditatedly, with specific intent to kill. And there's a fifth element, the fact the defendant acted without justification. Let's go through those then. Beyond a reasonable doubt, you got the instruction, and this is just going to be part of it. What it really means is that, and I'm blocking your view, I'll keep moving so I don't block everybody's view, is if after full and fair consideration of all the evidence, you are firmly convinced, then you no longer have a reasonable doubt. And remember we talked about in jury selection, it's not all doubt beyond a shadow of doubt. We talked about, is it possible that neighbors could have came and put some snow in the driveway, in the yard? Anything's possible, but is it reasonable? Remember that. It has to be beyond a reasonable doubt. Direct and circumstantial evidence. And there's nothing wrong with circumstantial evidence. You can consider direct evidence. You can consider circumstantial evidence. You can consider both. That was our example with the snow, the example with the mud tracks in the kitchen, the chain of facts to show something happened. The law makes no distinction. All right, so let's look at the first element. State has proved beyond a reasonable doubt that the defendant strangled Mark Hoster. Second element, Mark Hoster died as a result of strangulation. State has proved it beyond a reasonable doubt. Third element, the defendant acted with malice aforethought. So what does that mean? You're going to get an instruction on that. We'll talk about malice. And when you see the instruction, it says it's malice, a state of mind, intentionally do a wrongful act, injury out of actual hatred, or with evil or unlawful purpose. And you notice the ors there. The state's not saying that the defendant hated Mark Hoster. They were friends. The state would agree with that. But when the defendant placed that bat on, or object, weapon, on Mark Hoster's throat and held it there for what seemed like an eternity to strangle the life out of him, that was for an unlawful purpose. Because he wasn't justified. He wasn't acting in self-defense. You can look at the act surrounding it for malice. Malice is forethought. That's what it is. Fixed purpose or design to do some physical harm. That's why you place a weapon on somebody's throat. And remember, it doesn't have to exist for any length of time. It's like premeditation. We talked about this in jury selection. It doesn't have to have an hour, 2 days, 20 minutes. It can be as long as a person had time to fix purpose of design. It doesn't have to exist for any particular length of time. You can also infer the fact that the defendant was using a dangerous weapon. The defendant's story is he used a baseball bat. Baseball bat is considered a dangerous weapon when it's used in the manner that he used it. State's Exhibit 52, Dr. Thompson talked about, this is the hyoid bone, state's recollection of the bone higher on your throat, and then the Adam's apple one is on the left. Remember he said the fractures were on the left-hand side, which is also consistent with the defendant being right-handed and holding that weapon on his throat, putting more force on the left side versus the right side. Mark was laying on the ground facing him. The force used was enough to fracture those bones. That's malice and forethought, ladies and gentlemen. The state has proved the first three elements. Now let's look at the fourth element. The defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill. These will all be defined for you in your jury instructions. Willful means it's not an accident. This wasn't an accident. This wasn't where Mark got bumped and fell down some steps. This was an intentional act. To deliberate means to weigh in one mind, to consider. We talk about premeditate. Doesn't mean plan. Doesn't have to be planned out that morning. The person wakes up and says, I plan to do this. It means the person had time to think or ponder before they act. And remember, deliberation and premeditation, just like malice of forethought, doesn't have to exist for any particular time. Specific intent. This is the example we talked about jury selection with the ironing boards, the ironing shirt. You should look at the facts and circumstances surrounding an event to determine what somebody's specific intent is. What is somebody's specific intent in this case? That's what we have to consider, the defendant's specific intent. Seldom capable of direct proof. Consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You get another you get the dangerous weapon inference. If the person has an opportunity to deliberate, use a dangerous weapon against another, you may, but you're not required to infer that. Ladies and gentlemen, it comes down to this for that fourth element. Is when the defendant is holding that mat down on Mark Koster's throat, does he have the time to think? Does he have time to ponder, deliberate, consider in his mind as he's holding it? He's not just holding it, as he's exerting it on his throat for up to 2 minutes. And up to 2 minutes gives a person time to think, gives time to consider. It's not like he's pulling it up. He's holding it there. It's only Mark couldn't even talk. He could grunt until he strangled the life out of it. That's time to think. That's time to consider. It's time to deliberate and premeditate. And you use that with a specific intent. That's to kill somebody. And that's what he did.
And I'm going to object to this. That is a misstatement of the law. He's referring to the time only. Again.
Go ahead. The instructions are the instructions. And if there's any inconsistency between what any attorney tells you at this time as to what the instructions are, you have them and you will follow what they are.
The state has proved each and every element so far beyond a reasonable doubt. There's one element left. The defendant acted without justification. The state has to prove he didn't do this in self-defense. And you got a bunch of justification instructions. But and you're going to have them all, but what it means is reasonable force is the amount a reasonable person would find necessary under the circumstances to prevent death or injury. The defendant's story to the police was Mark Koster came up to him, hit him in the shoulder. He said, please stop. Does that mean it's reasonable force then to grab the bat away, hit him in the head, knock him to the ground, and strangle him until he's no longer alive? Does that make any sense? Mark Koster was 5'10". He didn't weigh 140 pounds. We know that because Sandy Gierenfeld told you that he was thin. He was looking she was looking gray colored. He was frail. Dan Koster saw him in 2008, he weighed 140. So common sense says he weighed less than that. So this frail man apparently grabs a bat and hits the defendant on the shoulder. And all of a sudden that means now he has the right to defend himself, use this bat, club Mark Koster, and then just strangle him. It makes no sense. The defendant is 6'4". He weighs well over 200 pounds. He outweighs him. He could have just pushed Mark aside and said, knock it off. But he didn't do that. This isn't self-defense. defendant's not justified. When you're going to get this instruction, if the state shows any of these 5 things happen, just one of them, state shows just one of these things happen, he's not justified, it's not self-defense, okay? So these are the 5 things. If the state has proved any one of the following elements, the defendant's not justified. The defendant started or continued the incident which resulted in injury. An alternative course of action was available to the defendant. The defendant did not believe he was in imminent danger of death or injury, and the use of force was not necessary to save him. The defendant did not have a reasonable grounds for the belief, and the force used by the defendant was unreasonable. So that's one of the 5 things. We only have to show one. But you're going to get an instruction right at, this is going to be close to this. It's called 2 or more alternate theories. And what this means is, if you go back on those 5 things the state shows one of them happened and it's not justified, if 7 of you think number 1 the state proved, but 5 of you think number 2 the state proved, as long as you're unanimous on all 12, think of one of the 5 things happened. So in other words, 7 could say number 1 state proved, 3 could say state proved number 2, which I'll show you. We'll go back. So 7 of you think the defendant continued the incident, and 5 of you think he had an alternative course of action, then you're all unanimous, one of them happened. That's all that's required. Or if 3 think and number 3, whatever combination you want to get, as long as all 12 of you agree one of those 5 things happened. That's what the 2 or alternate theories means. Okay, so let's look at those 5 things. The defendant started or continued. Well, if you believe the defendant's story that he told the police, he says Mark started the fight. However, what he told the police is he knocked Mark to the ground. This 6'4" guy that weighs well over 200 pounds now is standing with a bat, and Mark Hoster, this frail man, is laying on the ground. He continued. The defendant continued this. He didn't have to do anything. He made the decision. Right there, state has proved he's not justified. But we can go through the other ones as well. Seemed like an eternity. This is a clip from the video you saw. This is without closed captions.
Well, I remember, best I can remember is once I got him, I hit him back a little bit. He went down, I went down top of him and across his thing. And he kept struggling and I kept pressing. And
how long would you say? 30 seconds, a minute? How long?
Seemed like an eternity, but I don't think it all happened.
It doesn't happen like that with that. You don't hold it or strike them.
I would say,
just a guess. You said it seemed like that, yeah. That's not quick for 2 minutes.
Up to 2 minutes. Seemed like an eternity. Number 2, an alternative course of action was available to the defendant. Mark's on the ground. He had an alternative course of action. It's called go in the next room, carrying him back. Could have called the police. Just said, hey, things are getting a little out of hand here. What do you think? This is the same interview where he talks about Mark coming at him with this bat.
So, but do you know what he was mad about?
Mark had something all the time. At that individual time, I don't know. He was cussing about something. Didn't want me staying up later than him. I'm going to take it no more. You know, he had to do with that. Did he? please don't, we can back and try to look again, and down here.
Said, please don't. Does that sound like a man that's describing to you something that he's scared for his life? That he's in fear of imminent danger? Even if you believe it happened the way the defendant claimed it happened, he wasn't scared of Mark. He outweighed him. He's a huge man compared to Mark. The defendant did not believe he was in imminent danger. He was asked, specifically by law enforcement, he was asked, what was going through your mind? Did he say, oh, I was scared for my life. I was fearful that he was going to really hurt me. He said, I didn't want to be there. Again, this isn't justification, folks. We talked about this in jury selection. If somebody pushes somebody, doesn't give a right to the other person to punch him, take him to the ground, pummel their head against a sidewalk. It's the right, you have that equal portion. The defendant was not justified also because of the reasonable grounds. We talked about the height-weight difference. The force used by the defendant is unreasonable. Even if you believe Mark Koster did have a bat, even if you believe that Mark Koster did hit the defendant on the shoulder, that doesn't equate to giving somebody free rein to knock down and strangle their life out. The state has proved the fifth and final element beyond a reasonable doubt, ladies and gentlemen. On behalf of my co-counsel, Mr. Smith, we'd like to thank you for your attention in this matter. We appreciate that. The state in this case has proved beyond a reasonable doubt the defendant is guilty of murder in the first degree. Because use your common sense. Actions speak louder than words. Everything the defendant did in this case speaks of murder, not self-defense. Everything he did during, before, and after show that this was a murder. He was trying to cover up the crime. He was trying to get away with the crime. And he almost did. At this point here, ladies and gentlemen, the state has proved beyond a reasonable doubt that he is guilty of murder in the first degree. Thank you.